Court of the State of Colorado is now in session. Chief Justice Oates presiding.
Please be seated. Morning, everyone. Looks like we've got two cases set on the docket for this morning. The first one, styled People v. Chavez-Torres. We've got that set for an hour. You all look ready and you know how to use the equipment. Ms. Nora Leda, why don't you begin?
May it please the court, Carmen Moraleda on behalf of the people. My attorney registration number is 34852. It's good to be back. So let's start with the framework rule that we are asking this court to adopt. An untimely merits claim of ineffective assistance of plea counsel regarding failure to advise or misadvise of the immigration consequences of a guilty plea does not establish justifiable excuse or excusable neglect because substantive allegations of ineffective assistance cannot circumvent the statutory time bar. First, as a question of statutory interpretation, the plain language of the statute does not include ineffective assistance as a sui generis exception to the time bar. Therefore, the crafting of such an exception should be left to the General Assembly as its prerogative. Second, the Wiedemer factors constitutes a pre-merits inquiry, mainly circumstances outside of defendant's control that prevented him or her from timely asserting a challenge, and do not look at the merits of a claim. Defendants must overcome justifiable excuse or excusable neglect as a threshold procedural requirement before they are entitled to argue a claim on the merits. Defendant here argues that also the cases that have held that ignorance of the law, lack of counsel, or the recent discovery of a legal basis to challenge a conviction do not establish justifiable excuse or excusable neglect are inconsistent with Wiedemer because they establish a bright line limitation on justifiable excuse or excusable neglect. To the contrary, those cases correctly concluded that those allegations as a matter of law do not establish justifiable excuse or excusable neglect. Otherwise, the statute would be rendered meaningless.
Why would that be, Ms. Moraleda, and good morning to you.
Good morning.
And maybe I'll just ask it this way. How do you deal with Padilla and Pozo? Those cases require counsel to advise. Padilla makes clear that there's no distinction between misadvice and no advice. And Justice Stevens in Padilla said no advice would be an absurd result because it would encourage saying nothing. Do those cases distinguish the cases that say ignorance of the law is no defense?
So we all agree, I guess, at this point that both Padilla and Pozo held that failure to advise or misadvise regarding the deportation consequences of a guilty plea may constitute or do constitute grounds for ineffective assistance of counsel. So, but the question is not whether those allegations constitute ineffective assistance of counsel. We do agree that those allegations may constitute ineffective assistance of counsel. The question is whether those allegations failure to advise or misadvise may constitute grounds for justifiable excusable neglect. And the answer should be no, because those allegations, substantive allegations of ineffective assistance of counsel should not circumvent the statutory time bar.
But why does it circumvent it? And I think we could all agree the reason you're entitled to a lawyer is you can rely on the lawyer's advice. If the lawyer tells you you have no problem, there are no immigration consequences here, and then you learn there are, why isn't there at least a factual question as to whether the lawyer's misadvice caused the client not to do anything?
So two reasons. I think the plain language of the statute, and even if you look at the Whittimer factors, those are factors that look at pre-merits inquiry. They don't look at the merits of a claim. Because if we were to look at the merits of a claim, then why do we have the statute?
Sure, but it really is a pre-merit. The question is, did something cause you not to pursue your claim on time? And the reason, at least the client would say, I didn't pursue it because my lawyer made clear to me there were no consequences. So it's not an issue of present need. It was, I really understood from my lawyer there was no reason, I had no claim to file, so I didn't file anything.
Well, I do believe that all defendants have a reason to question the constitutionality or of their convictions. And the statute exists for defendants to do that. The statute, this court in Whittimer and later in Mershon, clarified that the enactment of the 16-542 created the present need for defendants to raise constitutional challenges to their
But in that view, so in every case in which the lawyer tells you you have no immigration consequences, you need to file a 35C anyway just in case? Why?
Well, so we are trying to make a distinction between failure to advise or advice versus counsel telling you, I'm going to do something on your behalf. Like if post-conviction counsel tells you, I will file a motion, and then counsel fails to file the motion or files the motion untimely, I think that may constitute grounds as, for justifiable excuse. The difference is between what I call the naked advice or misadvice versus counsel's affirmative representation that he or she is going to take an action on behalf of the client. I think in that case, the defendant should be entitled to rely on that representation.
But I want to push on Justice Gabriel's question. So what you're saying is, in fact, a criminal defendant who's a non-citizen criminal defendant, or I guess a convicted criminal, should always file a 35C immediately saying, my counsel was ineffective because I suspect my counsel was ineffective because they may have failed to advise or misadvised me about immigration consequences?
Well, no, what I'm saying is that I think defendants, particularly this defendant who didn't have any legal documentation, he wasn't a permanent resident, I think they have a responsibility to take certain steps to make sure that their convictions, if they need to challenge, they do that within the statutory time bar. It's like, an example could be like, sometimes, we go to our doctors and they say, maybe you need surgery and you are not convinced and you seek a second opinion. So we are not putting any kind of higher standard on defendant. It's just as they're responsible, since we have a statute of limitations, for them to make sure that if they're going to challenge it, they do it within the time limits.
So I'm sorry, is that what you think is required? They have to get a second opinion in every case?
I don't think it's required. I just think the statute of limitation exists for a reason. And this court said the enactment creates the present need for defendants to raise constitutional challenges. And there, in Mershon, this court rejected his claim that he had no need to attack the conviction until he was charged as a habitual criminal.
But in Mershon, you didn't have a lawyer misadvising the client, right? I mean, here you have a lawyer who's telling a client, you're okay, this is not going to affect your immigration status. And you're saying that client has an obligation to go get a second opinion after the plea enters?
I don't think he has an obligation, but I think because there exists the statute of limitation, they got certain responsibility to I guess, double check that if they're going to do that, they do it within the time limits. Otherwise, why do we have a statute of limitations?
What is it that you think this defendant did wrong here? What was the neglect? What was it that this defendant should have done differently in order to be able to file a timely claim?
Okay. Well, this defendant didn't have any, he wasn't a permanent resident. He didn't have any legal documentation.
Yeah, my question is just related to what should he have done differently so he could file this a timely post-conviction claim? I mean, he had a lawyer. The lawyer tells him, this is not going to affect your immigration status, right? Or didn't advise him one way or another?
Yes, I
Okay,
think
and then you have a plea agreement that apparently didn't mention it, right?
Yes, the record here is silent as
But
to
what-
whether there was any advisement.
What should this defendant have done differently?
Well, maybe consult with an immigration attorney, since he was already illegally in the country.
Which comes back to my question. Is that what you're saying defendants need to do then? That it's on them to consult with an immigration attorney, even if they have a criminal attorney who's advising them, that they have a duty on their own to go consult with an immigration attorney?
Well, that might be the case, yes. As I was going to say, responsible citizens, that might be the case, that they
Even where
have
it's clear that attorney, the criminal defense attorney, has an affirmative obligation to advise this criminal defendant of these immigration consequences. Pozo is on the books, right?
Yes,
at the
so
time
your
of
question
this-
is, they do, yes, yes, it was.
I'm adding
Yes.
to.
This was in 1996, yes.
Correct, and so I'm simply adding to Justice Zamora's question. In this case, the criminal defense attorney had an affirmative obligation to advise this defendant of the consequences of this plea and failed to do so.
Yes, the record is silent as to whether she did or not, so we don't have, yes.
And even there, you're saying, in the wake of that non-advice or failure to advise, this defendant should nevertheless go find another immigration attorney and separately seek advice.
Well, I do think that the existence of the statute of limitations, call it like that, so requires. I mean, it's his responsibility to make sure that he presents a claim timely.
May I?
Please.
So was there any reference to immigration consequences during the Providency hearing or in the Rule 11 paperwork in this case?
No, Your Honor, there was a 96 case.
Does
There's
it-
nothing.
Okay, so does that make a difference?
Uh,
And in this case, unlike the next one, there's no reference to immigration consequences at all in the paperwork or or during the course of the Providency hearing?
Yeah, well, it's definitely more evidence if the Providency hearing or the plea agreement does contain that information. It certainly goes to the way as to why he should have inquired, or why he was on notice of those consequences and should have acted earlier.
What exactly did defense counsel say to the defendant here? What does the record reveal about precisely what he said?
It's silent, there's nothing. I mean, nothing that in the Providency hearing or the plea agreement. So, kind of to go back to my argument, so here defendant contended that he had established justifiable excuse or excusable neglect because he had no reason to question the constitutionality of his conviction until he was taken into the immigration enforcement.
I don't think he says he had no reason to. I think, or distinct from Rashan, it's not that he didn't need to. It's that he had no way of knowing there was a problem. Is there a distinction between he had no need to challenge and
Yes.
he had no way to know there was a problem to
Well,
challenge?
My answer to your question is that his claims boil down to allegations that he had no present need to challenge his conviction until immigration enforcement took him into custody. And also, he did not know his conviction rendered him inadmissible, and he did not know his plea counsel provided ineffective assistance, all insufficient to establish justifiable excuse or excusable neglect. So I understand your question, but I guess if you look at the substance, the essence of the claim, that's how I read it, that he had no need or no present need to challenge until he was taken into the custody of the Immigration and Customs Enforcement.
So, Ms. Moraleda, if I understand your position, you're not drawing a distinction between someone who is affirmatively misadvised, in other words, provided incorrect advisement, versus someone who's not advised about immigration consequences, right?
That is correct.
So, in a hypothetical, let's say you have a defendant who pleads guilty, and he's specifically told by his lawyer, they have a discussion about immigration consequences, and the lawyer says, don't worry about it, this is not going to subject you to immigration consequences, okay? That defendant pleads guilty, and under the rule you're asking us to adopt, or the holding you're asking us to make here, that defendant would still have a present need at the time the plea enters to file a Rule 35C claim.
Well, the statute creates the present need.
But that's the way you interpreted it, right? I want to make sure that your position is, even though that defendant's being told by his lawyer, by an attorney that he's hired or who's been appointed, an attorney who's representing him, and telling him, I've looked into this, you don't have any immigration consequence, you don't have anything to worry about it. That defendant has a present need to file an ineffective assistance of counsel claim from the moment that he pleads guilty, right?
Yes. And I understand that sometimes the merits of a claim can be very compelling, like here, having in my case, if counsel tells you, don't worry. But it's just the merits of a claim, no matter how compelling, are not a factor in the justifiable excuse or excusable neglect analysis. Because I go back to the same, if that's going to be the case, if we're going to look to the merits, then that's going to render the statute meaningless and defeat the legislative intent and purpose behind the statute.
Ms. Morleda, you said that a couple of times. Isn't the issue before us whether Mr. Chavez-Torres gets a hearing? All we're talking about is whether he gets a chance to prove justifiable excuse, right?
I understand, but what his allegations, as a matter of law, do not justify the hearing because they
So
don't.
tell me why. You've talked about I'm sorry to interrupt you, I apologize. In the Wiedemer factors, I mean, the first one, is there an existence of circumstances or outside influences preventing a challenge? Why isn't there at least a factual argument here that my lawyer didn't tell me, the plea paperwork didn't say a thing, those circumstances prevented me from challenging it. If I understood there was a question, I would have done something. Or, the better, perhaps the stronger case is if the lawyer tells you there's no problem. Why doesn't that at least get you a fact question as to whether there was a reason you didn't bring the challenge?
Well, that can be, I guess it could be interpreted like that, but again, I think a non-citizens defendants, I mean, the fact of the status here kind of should make them aware, or they should compel them to check whether their convictions are constitutional, whether they should do something else. I understand the Wiedemer factors are kind of vague and open to many interpretations, but we do not read them as allowing court to look into the merits of a claim, because.
I agree, that is fair. But in laying out those Wiedemer factors, we also made clear that the overriding interest is to ensure that the defendant has a meaningful opportunity to challenge the conviction. And it seems that at least in this particular type of allegation, this advice or failure to advise about the immigration consequences, and I'm picking up on a question that Justice Gabriel asked, seems directly tethered to the decision not to further inquire. This defendant walks out the door thinking, I'm fine, I have nothing to worry about. My criminal defense attorney, who had an affirmative obligation to let me know if there was a problem, has either not done that or affirmatively given me bad advice. So why is that not directly linked to the failure to timely pursue a post-conviction claim?
Well, I think I've said this, maybe it's not very clear. I think the existence of the statute is key, because if we were going to, every time counsel fails to provide or do something they were supposed to do, counsel has many duties. Counsel have a duty to provide effective assistance. So we're trying to get to is that if we were going to carve an exception in the immigration context, that's going to open the door to any other thing. Ineffective assistance of counsel is going to be kind of an exception, because counsel does not only have a duty to advise of immigration consequences. They have many duties. They have a duty to provide effective assistance of counsel. And if that's going to be the case, then that's going to become another exception. And we're saying that should be for the General Assembly as its prerogative.
I think, this is a strong argument that you make, and I understand it. But didn't the U.S. Supreme Court create this exception that you're worried about? I share your concern about this floodgates of any duty you might feasibly have. But in terms of, limiting the scope of this, doesn't Padilla do that? Padilla says you are affirmatively required, counsel, to give the correct immigration advice. Doesn't that solve your problem in terms of this floodgates? Padilla creates the exception. The U.S. Supreme Court did.
But the U.S. Supreme Court in Strickland said that counsel also has a duty to provide effective assistance. So I don't think that Padilla solved the question.
You don't see a distinction between saying if you committed ineffective assistance, that's justifiable excuse, versus when the Supreme Court says you have to give this piece of advice, you must. I guess I see a distinction there.
Yes and no, because again, there are other circumstances where counsel has to give specific advice or just provide effective assistance, and that could be exactly the same. Defendants are going to argue my counsel failed to provide good advice or as to whether to plead guilty or to go to trial, and now I'm entitled to go around the statute and file my claim.
Yeah, and I think that the point you make is well taken, but I think we would not, the rule at least we're positing to you, is not to say ineffective assistance is always just to get you a fact question on justifiable excuse. It's this brand of ineffective assistance because the U.S. Supreme Court has carved it out.
I don't think so. I think that if this court were to do that, it would be opening the gates to ineffective assistance of counsel becoming an exception.
So when you keep coming back to opening the gates, it sort of makes me think of, well, there are a lot of collateral consequences of pleas, right? One of which might be immigration, but there's also employment, public benefits, firearms. Is that all of what you're implicitly alluding to? Is these other kinds of collateral consequences that would potentially be implicated by a decision contrary to your position today?
Well, I guess
I'm just trying to understand what you're saying.
Yeah, so I guess that goes, there are other consequences of a good advice that do not accept defendant from, the time bar. But this would. Why is immigration different than any other consequences with also that can be harsh?
Well, I guess framing it the way that I just have, in terms of sort of a hierarchy of collateral consequences, would you agree that Padilla seems to say that the collateral consequence of deportation is of sufficient magnitude? Stevens talks about banishment, exile, that we're going to treat this differently. So Padilla does seem to say deportation, removal is a different kind of collateral consequence. Would you agree with that?
Yeah, they definitely talked about that, and it's definitely harsh. Of course, we agree with that. But there are other areas of the law, or other areas of misadvisement that also have harsh consequences, like a defendant who is subject or sentenced under the Sex Offender Lifetime Supervision Act have many consequences. They're also harsh. Even being sentenced to prison is a harsh consequence. Yet, we do not accept those defendants from the time bar.
But typically those, sorry.
No, go ahead.
Typically, those are going to be covered in the providency hearing or in the plea paperwork or both, right? So this idea, would open the floodgates. I'm just not sure that I buy that in terms of just the consequences of a plea. We're talking about the context of a plea, right?
Yes. And as Your Honor is aware, I think pretty much all the plea agreements and during the providency hearing, defendants are advised of the risk of the immigration consequences of the risk of deportation. So this case, it just happened, it's a 96 case, and for whatever reason, the record is silent as to what specifically he was said. It seems to be an anomaly, because now every day you see the immigration consequences and deportation risk, et cetera.
That's my point exactly, that I don't know about the floodgates. This seems to be sort of an anomaly.
Well, yes, because it's old, but yet our point is that we don't want to have this immigration deportation consequences ineffective assistance as an exception to the time bar. The plain language of the statute is clear, and the way Wiedemer is laid out doesn't seem that those factors look at the merits.
So,
And-
you were going to,
I was going to go a little bit different direction, so if you want to finish this line.
I was too, so.
Okay. Well, let me just ask, I assume you're relying on Mershon for the proposition. Remind me, what was the grounds by which Mershon was claiming ineffective assistance of counsel?
No, in Mershon, defendant argued that until he was charged as a habitual criminal, he didn't have a present need.
No, I
to
understand,
challenge.
but he still had to have grounds for why the claim was ineffective. Did he say he wasn't advised of his right to remain silent? I mean, what was his grounds?
Mershon was not an ineffective assistance of a counsel claim. It was just that he said that he didn't have the present need until he was charged. And this court said that as a matter of law, that argument was wrong. But it wasn't an effective assistance of counsel
Well,
claim.
why was he, what were his grounds for trying to withdraw his previous guilty plea then, I guess, is,
I don't think in Mershon there was a guilty plea.
it was a conviction?
Yeah, I believe so. But might be yes.
and it was just that he didn't challenge it within the 3-year statute of
Exactly,
limitations, because he
But
said
he still had to have grounds for why the conviction should be vacated. I'm just trying to figure out what were his constitutional grounds for having the conviction vacated?
Well, I guess he wanted to have, he just said that his motion was late because he had no need to do that
Understand.
before.
I guess the question, though, is
Okay.
what was his basis for post-conviction
Post-
relief?
post-
Does the opinion say?
Yes, I do not remember, Your Honor, to be,
Thank you, sorry.
Can I ask, so you have said we shouldn't consider the merits of the claim, and the merits of the claim is failure to advise, or in this case, failure to say, and lack of advice. So if we separate the claim from the merits, I think what Mr. Chavez-Torres would be saying is he didn't know he had a legal issue, so ignorance of the law. And there are some Court of Appeals cases that have said ignorance of the law is not justifiable excuse or excusable neglect. We've not said that.
correct, exactly, yes.
So, and I don't want to, I know you're not doing the next argument, but let me just ask that, so that the next argument involves misadvice. Do you think that there's a distinction between ignorance of the law when your lawyer has been silent and ignorance of the law when your lawyer has told you affirmatively, no worries, no problem? Is that still ignorance of the law, or is that something different?
It might be lack of legal counsel at that point. It might be a little different, but it could be ignorance of the law.
So again, even when your lawyer has told you the law says you're fine, it's still your ignorance of the law that shouldn't give you a justifiable excuse?
Well, that would be more difficult to justify, right? Because if you have an attorney who says that, but yet I think it would fall within, at that point, lack of legal counsel who could have advised otherwise. And
So I guess that brings me back to, and then I think I want to circle back and say maybe this is true for both lack of advice and misadvice. Couldn't ineffective assistance of counsel, in fact, be a justifiable excuse or excusable neglect argument?
well, I was saying no, because that's going to circumvent the statute.
But we haven't said that it cannot. That it's an area that we haven't addressed.
No, you have not, this court, yes. And I would like to reserve my 2 minutes for rebuttal. Thank you.
Good morning, may it please the court. I'm Anthony Noble, registration number 33910, and I represent the respondent, Israel Chavez-Torres. With me at counsel's table is Matthew Fredrickson, co-counsel in both cases. So I'd just like to clarify exactly what the claim of justifiable excuse or excusable neglect was in this case, and that was that Mr. Chavez-Torres had no reason to question the constitutional validity of his conviction until he was taken into ICE custody and was advised by an immigration attorney that this conviction renders him permanently inadmissible. He also had no reason to question the representation by his attorney until an immigration attorney advised him that he should file a petition for post-conviction relief on the grounds that he was denied effective assistance of counsel.
Perhaps we could pick up right about where we ended, my colleagues here questioning Ms. Moraleda. Maybe you could articulate your position with regard to whether effective assistance is simply an exception to the time bar, a claim of effective assistance, which I thought I heard some questioning suggesting, or if it's only if the basis for ineffective assistance has to do with a failure to adequately advise with regard to immigration consequences.
Well, first, that's not the allegation. The allegation in the petition was not that he was denied effective assistance of counsel and therefore he has justifiable excuse or excusable neglect. The allegation tied into one of the Wadima factors. And then also when you look at the Court of Appeals opinion, I don't think that that was the basis for the opinion, because what the Court of Appeals did was look at his allegations in the petition, all of the allegations, and then it applied this court's precedent. It considered all of the factors under Wadima, and then it determined that his allegations implicate at least two of those Wadima factors. So this is really just a straightforward application of this court's precedent and the application of the Wadima factors.
And so do I understand you to be saying then that you're not making the argument that Padilla creates an exception in effect with regard to failure to advise of immigration status, that would not always qualify as excusable neglect, or that ineffective assistance of any kind would always qualify as ineffective?
No, and there's no need to go there. I think the Court of Appeals discussed Padilla and the affirmative advice and the failure to advise in response to the Attorney General's argument, but this is really just a straightforward application of the Wadima factors. And there were two allegations made in the post-conviction motion which implicate at least two of the Wadima factors.
And could I ask you, because you started off before I interrupted you talking about no reason, would you maybe refine your argument and make it for us here about how that differs from Mershon's dealing with present need?
Yes, well, I mean, in this case, this is another thing that I need to clarify as well. In this case, we're not arguing that he had no present need until he was taken into ICE custody. By making this claim under Wadima, Mr. Chavez-Torres acknowledges that the present need to challenge his conviction was when the conviction entered. That was when he received ineffective assistance of counsel, and that's when he suffered the adverse immigration consequences of the plea. So he had a present need to challenge his conviction when the guilty plea was entered. But then when you look at the Wadima factors, even though he had that need at the time, he had no reason to question the validity of his conviction, and that's what forms the justifiable excuse in this case.
And do you think that would be that rationale would apply to any ignorance of the law situation? That is, I had no reason to believe that the law was other than I had been convicted of or I had been told. Would that always be a sufficient basis to get around a time bar?
No, Your Honor, this is just a very, very unique case. And the reason why it's unique is because, first, Mr. Chavez-Torres advised his attorney that he's not a citizen of the United States. His attorney then advised him to take the plea, with that knowledge. When you look at the plea agreement, there's no general advisement regarding immigration consequences, and the transcript of the Providency hearing also doesn't provide any advisement about immigration consequences. So what makes this unique is there was nothing at the time that he pleaded guilty to put him on notice that he should question the validity of his conviction. So in nearly all cases that followed this, in all counties in this state, there's a plea agreement that has a general advisement. So a failure to advise by defense counsel would not be sufficient to satisfy that factor under Wadima.
Do you think even under Padilla, this is something that a defendant has to be advised of in a Providency hearing? Or is it only a question of ineffective assistance if his counsel fails to give him adequate advice?
Advice of what, Your Honor?
Is this something that would render, is the failure of a court to give an advisement on immigration consequences, something that is not a collateral consequence, but a direct one, such that it would be an ineffective plea?
No.
So we're only talking about it being ineffective assistance of counsel if counsel fails to advise.
That's correct, yeah. And if counsel fails to advise...
But I'm not sure I understood what your argument was
Yeah.
about written plea agreements.
Well, in most cases, if counsel is representing a non-citizen and fails to advise the non-citizen of the immigration consequences, then there's a general advisement in the plea agreement that will put the defendant on notice that this conviction may cause him problems.
But you just said, did you not, that that's not required?
No.
And so you're saying sometimes that would work as a backstop if that were included in a plea agreement, but it wasn't here, so there's no backstop for a failure of counsel to make the advisement?
Well, the point that I'm trying to make is the fact that it's going to be very difficult for a defendant to challenge a plea, say 10 or 20 years later, on the basis that his attorney failed to advise him of the immigration consequences, because he was put on some kind of notice regarding those consequences by a general advisement in the plea agreement. So a claim of justifiable excuse is most likely going to be unsuccessful on the basis of failure to advise, because that advisement in the plea agreement should have given the defendant a reason to question the validity of the plea.
Well, you just said that's not required, though, didn't you? Why should there have had to be an advisement in the plea agreement or the providency before the judge took the plea? Why should that have been required to put him on notice?
Well, there shouldn't, but in nearly all plea agreements these days, there is a general advisement. And maybe you're not understanding what I'm saying, because what I'm trying to do is frame this in the terms of justifiable excuse or excusable neglect.
I guess where I'm sort of going with that is it sounds like what you're saying is this should be treated as excusable neglect or justifiable excuse because something was not put in the plea agreement that didn't have to be put in the plea agreement.
No. What I'm saying is that this case is unique. And the reason it's unique is there was nothing during the proceedings that would give him reason to question the validity of the conviction. So that's what makes this case unique. This claim wouldn't succeed in nearly any other case that's brought to the courts, with a general advisement.
Well, would that be true with regard to any other thing that counsel advised him of, or is this unique to immigration? For instance, what if his counsel advised him some defense that he had would not be a defense, erroneously advised him of that, and then he never challenged that within the statute of limitations period? Would it be justifiable excuse that his counsel had erroneously advised him with regard to a possible defense?
Well, the question is, Your Honor, did he have reason to question the validity of his conviction?
And I take it you're saying if his counsel advised him of something different, then he would never have reason to challenge that.
If his counsel gave him affirmative misadvice, and he's entitled to rely on counsel's advice, then he would have no reason to challenge the constitutionality of his conviction. Now, if his counsel fails to give him advice, and there's a general advisement in the plea agreement, then it's going to be difficult to establish that he had no reason to question the validity of his conviction. So what makes this case unique is the fact that there was no mention at all of possible adverse immigration consequences.
And so am I mischaracterizing? It sounds to me like what you're saying is anytime counsel gives affirmative advice that is wrong, that satisfies justifiable excuse exception on the grounds that the defendant had no reason to think otherwise because his counsel told him something different, not just with regard to immigration consequences, but with regard to anything, any defense, anything having to do with the elements, anything?
I mean, it could if that claim is not refuted by the record. But what you also have to remember is that this petition for post-conviction relief, this is the very first stage of 35C proceedings. So the allegations are accepted as true. So what this petition shows is that there are two allegations relating to justifiable excuse that implicate at least one or two of the Wadima factors. So then so there's some merit here to the claim of justifiable excuse or excusable neglect. So that should have triggered the court under the mandatory procedures under Rule 35C to order the prosecution to file a response. Now, in the response, the prosecution may implicate other factors under Wiedemer. So then there are a number of factors under Wiedemer that the court has to consider.
So do I understand you to be saying if any of the factors that were thrown out by Wiedemer were present, that would be enough to dictate that there had to be a hearing, regardless of what the other factors were or showed?
Unless they're disputed by the record, because you might make an allegation in a post-conviction motion that the court could just look at the record and say, well, that's not going to go anywhere. So for instance...
But we have said unless the allegation fails as a matter of law.
Yeah.
I mean, I share the concerns the Chief is getting at, and I'm worried that your argument may be too broad. It strikes me the argument would fail as a matter of law, the example about the defense that the Chief gave. I don't think saying you didn't tell me I had a good defense is going to get you justifiable excuse. That feels to me like it goes to the ignorance of the law issues, which is why I thought you were going to be arguing to us, and I'm a little surprised here otherwise, that Padilla does make this different. So help me then understand why, if I'm having trouble articulating the question. Why doesn't this fail as a matter of law then, if that's the argument? If it's just, you got to tell me of any consequence and it wasn't. I'm concerned about the breadth of your argument, I guess.
Okay, so one of the Wiedemer
Was my
factors-
question clear? I was having trouble getting it out. Let me try again, because I don't think I
narrow in the scope of the...
Yeah,
Are any of our questions clear?
Mine, I'll stipulate, mine was not. I understood what you were saying, I think, about, there's no advice whatsoever. But the plea paperwork did say, even though it didn't require it to, it said there may be consequences. Now you have a reason to question, I think, is your argument.
That's correct.
Right.
Yes.
And regardless of whether it had to, the plea put you on notice even if your lawyer didn't say anything. Right? I get that. I have far more trouble with saying you get justifiable excuse or an argument for it just if, gee, I didn't think I had a defense, but 9 years later, I may have a defense that he didn't tell me about or misadvised me about. That strikes me as somewhat different than immigration consequences. So I guess maybe I will ask you to focus on that. Do you not see a distinction between immigration consequences and the misadvice about, say, a defense?
Yes, I certainly do, and it's an affirmative obligation of counsel to advise of the immigration consequences. But the gist of my argument really is that this case can just be resolved on this court's precedent and a balancing of the Wiedemer factors. So allegations were made here that implicate at least two of the Wiedemer factors, and that alone is sufficient to go to the next stage. Now, it doesn't mean that we're going to win on that allegation alone, because there's still proceedings that have to follow.
But let's, and again, I would have concern about a rule that says if you just voice Wiedemer factors, you're okay. Is it your position that if the defendant in a case says, my lawyer misadvised me about whether I had a defense, that's the reason I didn't challenge it, I get a hearing, why wouldn't that fail as a matter of law?
Well, how does that tie into the Wiedemer factors? I mean, is that the same kind of argument here, that he had no reason to question the validity of his conviction?
Yeah, well, that's what I'm saying. That is the first factor, right? I had no reason to question it because you misadvised me. But it would strike me that that's a straight-up ignorance of the law argument that we've said fails as a matter of law for justifiable excuse, I think.
Well, I don't think this court has ever said that. The Court of Appeals has said that, but those cases seem to be limited to ignorance of the post-conviction time bar. And really, this whole issue about ignorance of the law, aren't some of the Wiedemer factors actually ignorance of the law? The Wiedemer factors themselves are the defendant was ignorant of the law. And that's he didn't know that his conviction was infirm, and he had no reason to question the constitutional validity of the conviction. Basically, that's an ignorance of the law factor in Wiedemer.
Do you think Wiedemer actually says something that, with regard to ignorance of the law in that way? Even with regard to saying you had no reason, is that what Wiedemer says, or does he say something interfered with your ability?
Well, there are two different concepts. I think one is justifiable excuse and one is excusable neglect. So if something's interfering with your ability to bring a timely petition, then that's going to be a claim of excusable neglect. Justifiable excuse is a different concept. So Wadima itself doesn't actually say ignorance of the law, but you can characterize some of those factors as basically saying that the defendant was ignorant of the law. He didn't know his conviction was infirm because he doesn't know the law.
Might be a good point. Could you sort of flesh that out and show us what in Wiedemer you think goes to ignorance of the law?
Yeah, one of the factors is that whether or not the defendant knew his conviction was infirm or whether he had reason to question its validity. So that itself, could require some knowledge of the law. And if the defendant doesn't know the law regarding whether or not a conviction is infirm, then his ignorance of the law is actually one of the Wadima factors that should be balanced with all the other factors. And the Court of Appeals has never gone as far as saying that ignorance of the law to that extent is not one of the Wadima factors.
Mr. Noble, why doesn't Mershon, over here, why doesn't Mershon apply?
Because in Mershon, it was just a very, very limited claim that he had no present need to challenge his conviction until he was taken into habitual criminal proceedings. So we're not arguing that he had no present need to challenge his conviction until he was taken in removal proceedings. We're arguing that he had that need to challenge his conviction when it entered. But the delay is justified by the fact that he had no reason to question its validity. So my understanding is that in Mershon, the defendant never said that he had no reason to question the validity. He just said that he had no previous need to challenge it, and that defeated the whole purpose of the statute. So if my claim, or if my client's claim had been he had no present need to challenge the conviction until he was taken into removal proceedings, then that claim would fail under Mershon.
Let me give you an example, I guess, because I'm concerned about the floodgates being opened. Let's say an attorney tells a client says, I think I have an alibi defense, and the lawyer says, that's never going to fly, that's no good. And let's say it's this defendant, and then he gets arrested 16 years later for immigration consequences for that, because he enters into a plea. Would that then allow him to file ineffective because the lawyer misadvised him on an alibi defense?
Well, I think, first, that's a very distinct claim from the claim that's being pursued here, because there's
Well,
no...
what I'm trying to do is assess the consequences. So are you right? I'm not saying it's the same. I'm asking you, why is it different?
Because there's no correlation between the infirmity in the conviction and the occurrence of him discovering the infirmity. Whereas here, there's a direct correlation between the infirmity of the conviction, which was failure to advise of the immigration consequences, and the event that triggered his knowledge of the infirmity of the conviction, which was being taken into removal and finding out that this conviction is a crime involving moral turpitude and renders him permanently inadmissible.
We'll say it's the same exact crime, and he says, I have an alibi for when this trespass took place. And the lawyer says, I think it's a bad idea to pursue it. We should accept this plea agreement. Are you saying that under the exact same circumstances, he would not have an ineffective assistance of counsel or excusable neglect to raise this post-conviction?
So what you're saying then is that...
It's just a different kind of attorney malfeasance.
But what you're saying is that you're drawing some correlation between the new case and the old case, that through the new case, he realizes that he would have had this claim in the old case, and that...
Not new case, he got taken into custody for immigration consequences, and now he wants to withdraw his plea with regard to the trespass, just like he does here.
But then there's nothing regarding being taken into custody that alerted him to the fact that the conviction may be infirm. Whereas here, there's a direct correlation between being taken into ICE custody, finding out about the conviction and its consequences, and it may have been denied ineffective assistance of counsel, and the plea that he entered. So I think that would be one way of looking at this that would limit the scope of, I mean, you're not really pronouncing a new rule here. It's just what we're asking you to do is just stick by your precedent and require the courts to go through the Wadima balancing tests.
And you're saying Mershon is distinguishable?
Yes, because the only claim in Mershon was that he had no present need to challenge his conviction until he was taken into habitual criminal proceedings. Now, the whole purpose of the time bar was to prevent those kind of claims being brought at that stage. So Mershon is distinguishable because we're not arguing that he had no present need to challenge his conviction until he was taken into ICE custody. We're arguing that he did have that need to challenge his conviction as soon as the plea entered, but is justified in the late filing of the claim because he had no reason to question the validity.
And now let me ask one more line of questioning, and I'll leave you alone. What if there was a Supreme Court case that said you need to advise the clients of alibi defenses under my scenario? Does that change the outcome? I mean, like Padilla says you have to advise of immigration consequences. What if there was a case that said you need to advise of alibi? Would that change the dynamics of this case at all?
I mean, it could, but I think you're putting far too much emphasis on the part of the Court of Appeals opinion that discusses the affirmative advice and the need to give advice on immigration consequences, when really, when you look at the main body of the opinion, it's just a straightforward application of the Wadima factors.
So is it your position, the fact that the Supreme Court in Padilla specifically directed counsel to advise of immigration consequences doesn't affect this?
No, it's part of the balancing test. It goes to whether or not he can prove this Wadima factor and persuade a court to weigh it in his favor.
Final question, I'll leave you alone. Does it make sense that there's not a Supreme Court case that says you need to advise about alibi defenses because it goes without saying?
It may.
But where immigration consequences is something unique, and the Supreme Court had to identify that. Does that make sense?
I think it supports the Court of Appeals opinion, the fact that counsel had this obligation to advise of immigration consequences. Because really, the question is whether or not the defendant had reason to question the validity of his conviction. And what the facts show in this case is that he specifically told his attorney that he's not a citizen of the United States. In return, his attorney advised him to take the guilty plea. And there was nothing else about these proceedings that put him on notice to question the validity of the conviction. So that's really all we need to know about this case, is that by making those allegations, we've satisfied at least one of the Wadima factors. And then that opens up an inquiry into the balancing of the factors.
Mr. Noble, I'm sorry, you keep talking about the Wadima factors, but the issue before us is just whether someone gets a hearing or not.
Yes.
So what guidance do we give the trial courts if we were to adopt your approach? I mean, does it take one factor? Does it take two factors? Is there one factor specifically that's more important than another? I mean, how do trial courts go about deciding in a fairly predictable and uniform fashion when to grant a hearing and when not to grant a hearing?
Well, this court has instructed trial courts to consider all of the factors.
But that's with respect to the merits, not with respect to whether you get a hearing or not, right?
Yes.
I mean, we've talked about these are the factors that apply when you're determining whether someone has established justifiable excuse or excusable neglect. We didn't list those factors to determine whether someone gets a hearing or not, right?
No, but those factors have to be proven at an evidentiary hearing, and the purpose of the post-conviction motion is to make allegations that, if true, could establish the claim. So here, the Wadima factors, this court has said that a court has to consider all of the factors. Now, some of the factors relate to excusable neglect, some of the factors relate to justifiable excuse. Some of the factors would weigh in favor of the state. Some of the factors would weigh in favor of a defendant. So there's no petition that you can write that would address every single factor, because it's impossible for every single factor to apply in any given case, because there are competing interests and different types of claims. And clearly there's a distinction between justifiable excuse and excusable neglect. So if you're arguing justifiable excuse, it may be because there is no excusable neglect, but you can still succeed on one or the other.
And may I ask, in that regard, coming back to sort of, we talked about the Wiedemer factors, do they actually even say one thing cuts one way or the other, or do they just throw them up as wethers, and these are things to be considered? Not indicating that if you don't have a reason to challenge, that would be grounds for excusable neglect or justifiable excuse.
Well, there has to be a balancing of the factors. So the purpose of the pleading stage is that the defendant puts forth the factors that weigh in his favor. If there's some merit to those factors, they implicate, one or two of the Wiedemer factors, then the prosecution would be ordered to file a response in which they would say which factors weigh in favor of the state. And then a reply would be filed, and then the court has all of the allegations of all the relevant factors, but to decide those, there'd have to be an evidentiary hearing to determine the credibility of the witnesses and resolve, which factors actually apply. But once the court's made its factual findings, then there's a balancing test where the court has to balance all of the factors and the different interests. So the court's purpose under Wiedemer is to balance the defendant's interests with the state's interests and society's interests. And it's at that stage the court will decide whether or not justifiable excuse or excusable neglect has been established.
Can I ask just one slightly different question, because we're running low here? So the way you've argued about not having a reason to challenge the earlier advice or assert ineffective assistance, that there was some defect, does that have any outside limit in terms of time in your understanding of does our statute incorporate any notion of sort of latches or an obligation to do something at some point? Or are you just saying, until something comes up that would give me a reason to challenge what happened down below, the time just doesn't run?
Well, the older the case gets, the more problematic it gets, because
this one seems pretty old.
Yes, and there are two factors that would balance that. So, for instance, under Wiedemer, the court has to look at how much time has passed since the conviction was entered, and then the court also has to consider if there's any prejudice to the state, if the state's ability to defend against the claim has been impeded by the passage of time, so that the older a case gets, the harder it's going to be to disprove those two factors that would weigh in favor of the state. So, usually if you file a post-conviction motion in just a few weeks or a few months or a couple of years, there's a greater likelihood that you could succeed under a claim of justifiable excuse. But under this case, yes, it's going to be extremely difficult because the state's going to have a very compelling argument about being able to defend against such an old case. And that's something the court would balance.
With regard to a few months or a few years, that clearly falls within the statutory time limit. Does it seem that the legislature has made some kind of an assessment about what would be reasonable by setting a time limit? And only if there's some justifiable excuse if you fall within the time limit, you don't have to come up with any excuse, right? The legislature's already made the determination that's a reasonable time to file.
Yeah, and if you remember, it was this court that instructed the legislature to put in the exception for justifiable excusable neglect because of due process concerns. Without a meaningful opportunity to challenge a conviction, then a defendant could be denied due process. So all of this does really, it opens the door to a balancing of the factors. And it doesn't necessarily mean that we'll succeed just because he's got this reason for the late filing of his petition.
Mr. Noble, can I ask you to go back to the correlation? Obviously, I'm struggling with trying to make not having too broad a ruling. The argument you made about the correlation between the misadvice and the consequence strikes me as a possible limiting factor here, and maybe I could ask you to explain that. I gather in this case the advice was there were no immigration consequences or was not advised. And then lo and behold, ICE picks the guy up, picks up your client, and now he knows. Whereas perhaps an alibi defense where you weren't advised, there wouldn't necessarily be a correlation. Could you help me articulate, if we were going to adopt your principle that there has to be a correlation, how would we say that?
I think you said it.
Oh, I don't know that I did.
Yeah, but I think that there really has to be some correlation between the event that triggered the knowledge about the infirmity of the conviction and the infirmity itself.
So the failure to advise about an alibi defense, Justice Boatwright's argument, hypothetically, the Supreme Court said you have to advise about that. It would have to be whatever triggered the defendant in that case to figure out, oh, I was misadvised, would have to have some relation back to the misadvice. In other words, it can't be just somebody else told me, randomly. There has to be the connection. I'm just trying to articulate what that connection is.
Well, I think that would be some way of limiting it. There has to be something in the event that triggers the knowledge that relates back to the plea that was entered.
Okay, thank you.
Thank you.
Less than 2 minutes. I would like to make 3 points. So the essence of the defendant's claim is that his counsel's ineffective assistance was the cause of his untimely motion. And that is tantamount to asking this court to add an exception to the statute that does not presently exist. Second point I would like to make, this defendant waited 2 years after he was on notice of the removal proceedings to file his motion from June 2013 to May 2015. That fact alone should dispose of his claim. He established justifiable excusable neglect, because at that time he was on notice of the grounds that he alleged caused the delay.
I know your time is limited, but isn't that just to go to latches? Isn't that the argument you would make at the hearing? It's a Wiedemer factor. You waited 2 extra years. You should lose.
I don't
Why
think,
is it lose as a matter of law because of that?
Because his grounds should be rejected as a matter of law. Because it's just asking this court to add an exception that does not exist. And to answer Justice Boatwright, in Mershon, defendant did file a post-conviction motion, and he challenged the constitutionality of his prior convictions. And this court said it was too late. And with that, unless you have any other questions, we ask that the Court of Appeals judgment be reversed. Thank you, and I'll see you this afternoon.
Thank both counsel, appreciate the arguments. Case will stand submitted, and the court will be in recess for 15 minutes. Thank you. Please be seated. All right. Next case on our docket this morning is styled People versus Alvarado-Hinojos. We've set this for an hour. You gentlemen are familiar with all this operation. If you're ready, Mr. Michaels, why don't you get started?
Good morning, Your Honors. May it please the Court. My name is Joseph Michaels, attorney registration number 40403. I'm here today on behalf of the people of the state of Colorado. I'd like to start, I think, by recognizing the sympathies and compelling interests that are associated with the immigration context. It is a difficult situation, but this case is not about that. This case is about a rule clearly written, a legislative policy clearly expressed, and it's about recognizing that legislative policy and applying it as written. Not 2 years ago, this court in the Chavez-Castro case recognized and explained and emphasized that defendants, even in the immigration context, are required to abide by the rule as plainly written, and that is all we are asking you to do here. 165402 provides a mechanism. It gives all defendants the duty to investigate the effectiveness of counsel at the moment of conviction. It doesn't make an exception for immigration concerns and doesn't make an exception for citizen versus non-citizen defendants. That principle in Chavez-Castro applies equally to interpretation of this statute, 165402. In this respect, it is the defendant's burden to show that the statute is unconstitutional as applied in the immigration context. It is incumbent on the defendant to show why there is a justifiable excuse or excusable neglect that could not have been discovered and that did not originally adhere from that time of the conviction. The people in this respect are not asking for any sort of a new rule. We are asking for you simply to reaffirm the rule that you already have, which is that a substantive allegation of ineffective assistance of counsel regarding an attorney's advice does not defeat the procedural time bar of 165402. Rather, this court has already recognized one of the mechanisms and the only mechanism to defeat it based on attorneys' ineffective assistance of counsel, and that's the failure to act or to pursue a line of appeal or an argument that has been promised to a defendant. In other words, action or inaction. And I'm referring, of course, to the close case in that where a defense counsel failed to file a claim that would have been meritorious. There are three reasons primarily that this court should reverse the Court of Appeals holding based on that foregoing. The first is that the clear statutory language simply has no exception for immigration. The second is that, as opposing counsel conceded essentially in the previous case, and I suspect will probably do the same here, recognize that the present need originated at the time of the conviction, and thus it was untimely. Where, of course, opposing counsel and I will disagree is whether or not justifiable excuse or excusable neglect was present. But here there was none, and that's clear from the face of the record. And the third, of course, is that there's a legislative policy determination at issue here, and that policy determination is the determination of whether or not to include immigration as sort of a special claim.
But why, Mr. Michaels, you talked about the legislative policy, but the legislative policy includes justifiable excuse. In fact, based on Germany, we said it needed to be there, right?
Correct.
So I guess I'm not understanding what's inconsistent with legislative policy to say a defendant gets to argue justifiable excuse.
Justifiable excuse, the defendant certainly can argue justifiable excuse. We're not arguing that they can't. We're arguing that a substantive claim of ineffective assistance of counsel based on advice is not justifiable excuses.
So why is it your position that the defendant, notwithstanding absolutely incorrect advice, again, contrary to Padilla, there are no consequences. You got nothing to worry about. That the defendant in every case has an obligation to go check that? They have an obligation based on, it seems, my concern is your argument is that present need overrides everything. And so it sounds like your argument is Even counsel told defendant there's no immigration consequence. Notwithstanding that, it is the defendant's obligation within 3 years to go talk to another lawyer to see if counsel was right.
There's a lot in that question. I'm going to try to break it
Sorry.
into parts.
I
but
tend to do that. I'm
will-
sorry.
You'll beg my forgiveness if I ask you to repeat part.
By all means.
So the first part of that is that it's not my argument that present need defeats the substantive claim. It's this court's own statements in Mershon and Wiedemer, and to a certain extent in Close as well. But I'm glad that you invoked this idea of Germany, because I will come back to the Germany case in a minute. The statute is what creates that present need. The statute is what makes the defendant. There was some talk in the previous argument about, well, what about ignorance of the immigration consequences? It's not about the ignorance of the immigration consequences. It's about ignorance of 165402. It's a defendant's responsibility to investigate any claims. That time bar, that 165402, creates that present need, creates that incentive for the defendant to look into it. If the defendant does not look into it, then the time bar, the procedural time bar, is presumptively cuts off any and all claims.
But so on what? Help me understand then. When would you ever have justifiable excuse or excusable neglect? The defendant, if I'm understanding your position, always has to investigate within that 3 years and bring the claim, because there is always a present need. End of story.
Yes, that's correct. And that's
So when would you have justifiable excuse? Does your argument, my concern is, and I'm just playing devil's advocate with you, that it sounds like present need would essentially eradicate justifiable excuse or excusable neglect, because you always have present need at the minute of the conviction.
I see what you're saying. Present need, it's our position, and it's based on this court's own holdings from Mershon and Wiedemer, that present need is sort of a threshold determination, and then you evaluate whether justifiable excuse or excusable neglect applies. Justifiable excuse or excusable neglect does not consider, however, a substantive claim of ineffective assistance of counsel. That's where opposing counsel and I differ, and I'm a little bit at a loss because most of the briefing focused on immigration as being sort of a special exception, and in the previous argument, counsel got up and said, well, we agree that he had the present need at the time of the conviction. We agree that that present need expired, and therefore his claim is untimely, and now he's just, the argument simply seems to be that, is this justifiable excuse or excusable neglect or not? And so to counter that point, and I'm happy to talk about Padilla, and I'm happy to talk about why immigration is not a distinguishing factor in this, or should be considered a special circumstance in this case. But justifiable excuse has never considered a substantive claim. In fact, that's the entire purpose of the time bar. And that's what this court, in its opinions from Germany to Moland to Wiedemer to Mershon, recognized. And I think maybe an example that I can sort of trace through those will help a little bit. In Germany, of course, the statute 165402 did not have a justifiable excuse or excusable neglect exception. And this court found that that was unconstitutional. And it cited a number of cases in the opinion about why some claims simply couldn't be found in a timely fashion. And one of those cases that it cites is a U.S. Supreme Court case called Henderson versus Morgan, which talks about the erroneous advisement about a critical element of an offense to which a defendant pleads guilty, a substantive claim. I think we can all agree on that. And the Germany court really emphasized that case throughout its discussion of why you have to have this justifiable excuse, this exception. And so the legislature came back and added the justifiable excuse exception. And that has subsequently yielded Wiedemer and Mershon, which then talk about this idea that at the time of Wiedemer, you could, at the time of Germany, the argument was subsequent events, subsequent discovery, i.e. ignorance of a substantive basis, would have been enough to have triggered a constitutional concern about the infirmity of the defense, right? But then the justifiable excuse, excusable neglect subsection came in, and this court has now this court changed its tactic and said, we don't look at the subsequent events anymore. We don't look at this idea of ignorance of the law anymore, because you have that present need that starts immediately upon the conviction, and the legislature has identified a particular time frame, whether it's a felony, a misdemeanor, or a petty offense. And if you the defendant, don't make that allegation within that time frame, then we presume then that allegation is just extinguished, because the responsibility, as it always is in this post-conviction context, is on the defendant to look, even if they don't think that there is a constitutional infirmity necessarily. And that's why it's one of the constitutional infirmity question. It's one of the Wiedemer factors.
Yeah, and I think I do understand the distinction you're trying to make, but I guess I'm having trouble envisioning what would ever constitute justifiable excuse or excusable neglect under your framework. Can you give me an example of what would be justifiable excuse?
Yes, certainly.
Excuse me.
And I'm going to cheat, and I'm just going to point at case law. And I'll start with a close case where there was a public defender. It's much more complicated than what I make it out to be, but basically there was a public defender who was representing the defendant at trial, and then the first round of post-conviction appeals, and the public defender didn't raise a specific, arguably meritorious claim. And the court rejected the post-conviction attack, and then it came back, and the defendant had an ADC or a private counsel, I don't recall which, but for purposes, it was not the public defender, and they identified that claim that the public defender had failed to raise because of either conflict, potentially because they'd have to basically say they were ineffective themselves at the trial level. And this court said, well, that was a claim that could have been raised or should have been raised by the party as they were represented. And so it's this inaction. And that, I think, is the difference that we're really looking at. It's this idea of action versus inaction. And so the court said that even though it was untimely, that claim was worth considering because it was the attorney's failure to pursue something on behalf of the client.
But isn't that, and I'm playing devil's advocate with you, I'm just to try to understand your argument, isn't that effectively saying counsel was ineffective, therefore is justifiable excuse?
No, and the reason is it is different. So I'm going to backtrack. The answer is yes, counsel would be ineffective in that, but it's the quality of the ineffectiveness that's different. We're not talking about advice, we're talking about action. We're talking about the client putting a responsibility onto the attorney to pursue something on that client's behalf.
All right, so if counsel, they identify the claim and counsel just blows it and files it too late and then it gets struck, that would be justifiable excuse.
Yes, and in fact, there's a Court of Appeals case that says that. And same thing with there's a Court of Appeals case that talks about counsel filed an initial 35C and then waited something like 7 years to file a supplemental claim or a supplemental argument. And that also was justifiable excuse. Because again, it's the counsel failing, the counsel representing to the client, I'm going to do something for you, and then not doing it. Because at that point, the client is entitled to rely on the action that they are assuming the counsel is going to pay for. Now let's contrast that with the facts here and the facts in Chavez-Torres, where we're talking about advice or misadvice or lack of advice. As this court well knows, defense counsels already have an affirmative duty to properly advise. That is the substance of any claim. There is nothing about immigration that makes it a special duty to correctly advise or to failure to advise such that it would proceed, a substantive claim would trump the procedural time bar. There was talk this morning about Padilla and Pozo and whether immigration has a special status. I can tell you it does not. And the reason I'm telling you that, and I understand that argument sounds skeptical, but what Padilla did is it didn't say immigration is more special than other direct consequences of a plea. It doesn't say that you have a higher obligation, you have a higher obligation to have an immigration advisement versus a correct advisement about the elements or a correct advisement about the sentencing aspects. What Padilla said is, before Padilla, immigration was sort of down here at a sort of a lower level. It was considered maybe a collateral consequence, maybe slightly elevated above a collateral consequence. Padilla made clear that immigration is essentially a direct consequence. So you have the duty, the defense attorney, to correctly advise about it. But that's it. That's just a substantive claim under the federal Constitution. That's it. It's a substantive allegation of ineffective assistance of advice, not action.
So if you characterize it as a direct consequence after Padilla.
If I characterize it as a what?
A direct consequence Doesn't that equate with saying it's necessary that the defendant be advised of that and know it in order to make a knowing, voluntary, and intelligent plea? And that's not the case, is it?
That's not the case, and that's not what Padilla held either. It didn't say anything about that. It was simply talking about advice by attorney.
So that's not what you meant by saying it's a direct consequence?
Not to the extent that it impacts pleas. That's a different question for a different case, for a different time, for a different attorney.
Mr. Michaels, good morning.
Good morning.
I struggle a little bit with the requirement or the factor of present need, because we listed that as a factor in Wiedemer, right?
Not explicitly, no. You talk about I think you're referring to the first and the second factor.
No, whether the defendant has a present need to challenge a conviction.
Oh, had immediate reason to question his guilty plea? Is that what you mean,
So-
the second factor?
Right, and we've talked about present need. I guess what I'm wondering is, do you see a situation when present need would not start at the time the plea enters? I mean, is there always a present need automatically from the time a plea enters?
Yes. And the reason that the reason I say that is because of this court's decisions in Fagerholm and the enactment of 165402, Mershon and Wiedemer, which were all very clear that present need starts at the time of the conviction.
And I'm aware of that. And my question is, why have this as a factor, or why even talk about it then? I mean, it's always going to be the case, right? So what difference does it make?
It makes a difference because it does impact the ultimate justifiable excuse or excusable neglect discussion. What are the reasons that the present need might not have been met at that time? For example, let's say a defendant is sentenced to 20 years in prison. This is thinking off the cuff, but a defendant is sentenced to 20 years in prison, and at some point in the first year or two falls into a coma. The defendant has the present need from the time that conviction enters, but has no ability to do anything for the next, say, 5 years. So you look at this idea that, okay, he had 1 or maybe 2 years before he fell into a coma, that he could have pursued it, but then you have this sort of tolling provision. So it provides courts a tool to assess the entire time period under which the defendant did not pursue the claim. So it becomes not just a threshold determination, you defendant did or did not pursue this in a timely fashion under 165402, but it also allows courts to parse what reasons existed or did not exist to excuse that throughout. And that's what the second aspect is what the factor 2 in Wiedemer goes towards.
Counsel, can I bring you back to the close case?
Please.
I'm struggling a little bit with the distinction that you're asking us to draw between that case and this case. They strike me as actually very similar. So in the close case, the public defender made a bad argument in the sense that he left out something really important. Here, the attorney gave bad advice in the sense that he said there were no immigration consequences when there were clear immigration consequences.
I want to disagree with that principle from the outset. There were no clear immigration consequences, but I take your question. I'll come back to that.
Okay. Later, in close, after the time was up, another lawyer said, well, that was a terrible argument. It completely missed an important argument. And the court said it was justifiable excuse because the first lawyer had not made the best argument. Here, the first lawyer had not given the good advice, and a later lawyer said this was bad advice. Why aren't those really the same?
The difference in close was not just the failure to pursue one claim. It's that there was a conflict of interest in the first instance with the public defender representing that defendant on appeal after having represented them at trial. And so bootstrapping that up with the idea that the public defender simply did not pursue a claim that would have potentially implicated that office at trial becomes problematic in not filing a claim, not actively pursuing the action of pursuing a claim that existed.
But so wasn't that essentially because the lawyer had a conflict, it was ineffective assistance of counsel. So ineffective assistance of counsel was justifiable excuse.
It was the failure to pursue the specific claim that would have been pursued by another attorney.
It was
I
the
think.
type of ineffective
It
assistance.
was the
of
type.
counsel.
That's exactly it. I'm drawing a distinction between simple advice and acting on that advice versus action and inaction and reaction.
Could I follow up on that just briefly? I think I appreciate the distinction you're making about close, and you all have, about action and advice. But I'm not sure that I fully understand the policy reason why we would treat the one different from the other. And let me just ask you a close question, not with regard to close, but if, for instance, then your understanding of close, if counsel said, I'm going to file a post-conviction motion on your behalf, and he doesn't do it, that, under the case of close, might be an excusable neglect.
Correct.
But what if instead counsel had just said, well, we don't have to file a motion for post-conviction relief within this time period. We can do it any time. But he was wrong. That would be advice, I guess.
Correct.
Why would we want to treat the one different from the other?
Because the one where the counsel said, I am going to do this on your behalf, means that defense counsel will stop looking, stop seeking, and is relying on the fact that counsel is acting on their behalf. With the other one, it's counsel just messed up. And so it's a question of a substantive allegation of whether counsel was competent and whether there was prejudice, which would trigger a post-conviction motion if it was timely brought. But because there was no action on behalf of the client wasn't directly prejudiced because the client wouldn't have stopped looking, wouldn't have stopped seeking out other avenues, and wouldn't have assumed the attorney was already advocating on his behalf on that particular
So
issue.
effectively, is that argument, you can rely on what counsel tells you if he says he's going to do something,
Yes.
and you don't have to cross-check him.
Right.
But you can't rely on what he says if he just tells you you don't have to do something, and you do have to cross-check him on that.
Under 16.5402, yes. That 16.5402 creates that affirmative obligation on the defendant personally to have that reason to pursue any claim within a statutory time bar. And that's the same with any 35C. Plenty of courts reject 35Cs as a matter of substance, not because there are procedural bars, but because they just fail as a matter of law. But that doesn't stop defendants from pursuing them, as is their statutory right here in Colorado. 16.5402 is a limitation on that says, defendants, you have the right to pursue it, but it is incumbent on you to do it in a timely manner. Now, I do want to very briefly respond to my interruption of your question, which I apologize for, because I don't think that it was clear that this attorney was giving misadvice or bad advice about the immigration consequences of this plea. And I talk about that briefly at the end of my opening brief. And I don't want to rely on it, but at the time of this particular plea colloquy and plea hearing, well, first of all, we have the plea hearing itself, which says there may be plea consequences. So any defendant would have been on notice from the get-go, and that's something that Judge Daley recognized in his dissent. But I think more importantly is there was no clear word from any court in the entire country that this particular offense, third-degree assault with a domestic violence underpinning, was a crime of moral turpitude at the time of the plea. I'm not even sure that there was conflicting, but certainly all the cases that came out that addressed it came out after the plea.
Counsel, while you're catching a breath, I wanted to go back to something you said earlier to make sure I understand. It sounded like you were saying that our later case law suggested that present need functions as a threshold determination, and if present need is then established, we don't get to the other Wiedemer factors? Have I misunderstood your characterization?
That might be a little strong compared to my characterization. Threshold, the present need, 16.5402 imposes a present need. So in this case, it's 18 months. If the defendant does not file within 18 months, then the statutorily presumptive present need is not met, and therefore you have to establish justifiable excuse, excusable neglect under the Wiedemer factors. Does that clarify?
Thank you. And so I understood at least counsel's argument. He hasn't had a chance in this today yet in this argument, but in the last argument understood that he has present need and was simply trying to say that there was in fact justifiable excuse for the failure to bring it. So are we really fighting about present need here?
I think we are, because the argument through part of the briefing and the Court of Appeals below and the Court of Appeals opinion below was that immigration creates a special present need that triggers upon the time you find out about the immigration consequences, which is just not the case under Padilla and certainly not under the statute. And so I think present need is an important consideration, and maybe the crux consideration that this court first must address in terms of applying 165402 here, because 165402 presumptively creates and eliminates that present need. It creates that present need and eliminates it after the time bar cutoff. And then, and only then, do you talk about the justifiable excuse. But there's nothing about immigration that helps support a substantive claim of attorney ineffectiveness to create a present need, to create a justifiable excuse beyond that time bar. And that, I think, is where we disagree.
Another question before I let you go. It sounds like you were present for the last argument, and defense counsel argued that the Wiedemer factors themselves reflect some notion of ignorance of the law. I'm wondering if you could comment on that.
I don't agree with that
at
all. And the Court of Appeals cases that talk about ignorance of the law not being an excuse reflect an application of the Wiedemer factors to that extent. And to the extent that they do, they're both well-reasoned and have been repeatedly rejected of certiorari review by this court, which obviously is not a decision on the merits, but it's something that's been allowed to stand for a long time. The ignorance of the law, the 165402 says essentially, it doesn't matter if you have ignorance of the law. It doesn't matter any of that because the present need exists at the time of the conviction. It's on you, defendant, to seek it out.
So the factor, I'm looking at Wiedemer, and one of the factors listed is whether defendant knew that it was constitutionally infirm or had reason to question its validity. Is that not a version of, ignorance of the law, if you will?
I don't think so, not directly. I think it goes to a balance of whether or not the defendant had any sort of idea that it could be that there was a reason for the rule to be ineffective or for his conviction to be ineffective. But it talks about what outside circumstances would impact that ability. And here, there's nothing in the record that would impact that ability to create a substantive allegation of ineffective assistance that would create a pause or a reason to excuse that time bar.
Thank you.
Let me ask you if I could follow up on that one. On the first one, it sounds to me, the first Wiedemer factor, that you define it as a sort of a physical hindrance or obstacle preventing you. So I take it, I expect Mr. Noble to get up and say, there is an outside influence here. When your attorney misadvises you, that's a reason you didn't pursue a claim. You don't think that would fit within the first Wiedemer factor?
No, I do not. And that is because of 165402 and its express language requiring the defendant to act and investigate that conviction within that time bar. And you can look to the evolution of this court's treatment of 165402 to basically say that exact same thing, that a defendant's ignorance is not enough by itself to trigger justifiable excuse or excusable neglect to allow a substantive allegation of ineffective assistance to then bootstrap up and defeat the time bar, the very purpose of which is to prevent stale claims of
When has this court said that?
Mershon.
Mershon wasn't involving ignorance of the law.
No, but Mershon was involved in the present need, and Mershon explicitly talked about this idea that subsequent events do not, so subsequent events, which is to say ignorance of the law at the time, the present need of the conviction, subsequent events do not create a present need, do not create an excuse.
But Mr. Mershon was right inside of exactly what the legislature was trying to address in this statute. He could well have brought a claim, but he didn't need to because it wasn't having any negative impact on his life until he was going to be sentenced as a habitual offender. Then he was like, oh, darn.
Got it.
So, so I mean, that's like, oh, I didn't need to until it was going to impact my life. Here, I didn't know there was an issue. Seems very different from I didn't need to consider it until there was an impact on my life.
I don't think that I would agree with that assessment. I think you could say Mr. Mershon didn't think it would have an impact on his life, because very well, if he had gone on and never been convicted of anything else again, he wouldn't have had a reason for those prior convictions to have impacted his life.
But that was within his control, whereas here we're dealing with something that was in no way in the control of Mr. Alvarado-Hinojos. He had been misinformed about the law and was relying on that misinformation.
If that is the rule that you want to make, then that is going to impact everybody who has ever had substantive misadvice or failure to advise by counsel, including on elements on sentencing, on direct impacts, direct consequences of a plea. And that's not what Mershon held. Mershon talked about the subsequent event and the fact that the subsequent event did not excuse the prior ignorance or the prior failure to pursue the claim. And that's inherent in 165402. To the extent that it wants to be changed, that is a legislative policy determination. And if there are no further questions, I'm going to try to fit in 19 seconds worth of rebuttal. Thank
We
you.
won't make you reintroduce yourself. Understand that?
Okay.
Good morning. May it please the court. My name is Matthew Fredrickson. I am joined by Anthony Noble at council table. We represent respondent, Mr. Alvarado-Hinojos.
Forgive me for my presumption. That would be Mr. Noble arguing. I didn't mean to insult you.
No, that's all right, Your Honor, that's all right. I want to start by saying the Court of Appeals got this opinion correct, and that's because it took the Wiedemer factors and applied those to the facts, found that the facts implicated 3 of the Wiedemer factors, and remanded for a hearing. That's exactly what Wiedemer anticipates it doing, and the trial court doing, is holding a hearing on those facts. Specifically, Mr. Alvarado-Hinojos alleged that he was affirmatively misadvised by his plea counsel, told that his plea to third-degree assault with domestic violence would not have immigration consequences. He then went through the probation, successfully completed that probation, and it wasn't until recently, consulting with an immigration attorney, that he discovered that information was wrong. And so he filed his petition seeking relief under 35C. Now, as the Court of Appeals found, that implicated 3 of the Wiedemer factors. It meant that he, 1, didn't have reason to question the validity of his conviction, 2, did not have reason to know his conviction was infirm, and 3, it acted as an unavoidable hindrance to his ability to know what he needed to allege or the petition he needed to file, because he was responding to the reasonable advice or the advice he could expect would be reasonable from his counsel.
Sir Fredrickson, good morning. I'm sorry to interrupt you. Can I ask you, it looks like this petition was filed in July of 2015, right?
Yes, Your Honor.
And I couldn't tell from the brief when the consultation with the immigration attorney took place.
Your Honor, it's not alleged in that petition, but it does say recently, after the 2009 probation had ended and after the 18-month statutory requirement had passed. And that's what Judge Fox recognized to be true in the Court of Appeals opinion.
So you don't know when the consultation took place? Was it, can you give me a ballpark? Was it 2010, 2011? Was it 2015?
No, Your Honor, I don't know specifically when he came to discover that. He was waiting because he was waiting for his eldest daughter to turn 21 for him to be able to adjust his status. And then when he was prepping to do that is when he consulted with that immigration attorney and came to realize that the plea was, or the advice was inaccurate. So no, I don't know the specific date or year when he specifically did. I know it falls after the 18 months that the time bar explicitly limits him to, and was recent as of July of 2015.
Does it matter if he waited? Would it matter? Would it be relevant if he waited more than 18 months?
Your Honor, the specific time for when he's discovering and how he goes about learning of his pleas, of the inaccuracy of the advice he received, that's really something that could be on the balance of the facts. This is such a fact-rich analysis that him coming to it maybe days after the 18-month mark could have been balanced with other considerations, and that's why a hearing is required.
I'm sorry, maybe I asked that inartfully. I'm asking, does it matter how long he waited from the time he found out, in other words, at the attorney consultation, the immigration attorney consultation, and the time when the petition was filed? Does it matter if it exceeded 18 months, the 18 months that he was entitled to have initially?
It may, Your Honor, yes. The extent to which he waited and why would be relevant to that balancing of the Wiedemer factors.
Thank you.
But it wouldn't necessarily be a bright line rule or a bright line limitation on the exception, because it would have to come into play with all of the other things that Mr. Alvarado specifically knew, what he was specifically looking at, and what he was told and why and when. And those are all of that rich factual basis that requires a hearing. So I would ask that...
Can I interrupt right there just a second? Because getting back to where we've had this argument all along about how many factors or whatever. No. You seem to be saying there's a hearing is required if there is something in the factors that would cut in his favor of saying he didn't have a reason to know, even though there are other things that indicate that he did have a reason to know. You're saying that would require a hearing then?
Yes, Your Honor. I do submit to this court that we don't need to reach that in this case because it implicated 3 factors specifically, but on the ground level there, just upsetting 1 or 2 of those variables that don't butt up against a bright line rule would be sufficient for a hearing, because then the court needs to analyze how on balance those all work together in that factually specific case.
Let me just follow that up 1 second. This is the cases, and I get these mixed up, but this is the one where in the plea agreement itself, he actually was advised that his plea could have immigration consequences. So you've got a situation in which you're saying he's alleged his counsel told him otherwise, but we know in the record that he was advised that there could be immigration consequences. But so you seem to be saying the fact that there is a positive record that he was advised is not enough to foreclose a factual determination whether he had reason to know?
No, Your Honor. And I would point this court to a dialogue that's going on in the lower court between People v. Morones-Quinones, which is cited in the opinion, and People v. De Guglielmo, which is also in the Morones-Quinones case, where it was incumbent on the De Guglielmo defendant to inquire further when he received that advice and had received nothing from, received that information from the court, but nothing from his counsel. But in Morones-Quinones, Ms. Morones-Quinones had been affirmatively told there are no immigration consequences, and that was something happening behind the scenes that could make it so one believed your counsel, who has that duty to you, over the subjunctive suggestion that there may be immigration concerns that was written into the plea agreement. And that's what's happening here, is the affirmative, conclusive advice from counsel. This plea does not have immigration consequences above and beyond the subjunctive suggestion that it may have immigration consequences from the court.
So just to follow this out, so you're basically arguing where there is this kind of an ambiguity or an allegation that would run counter to something in the record, there's an obligation to hold a hearing, and then I take it that would mean what, at the hearing, the court makes a factual determination whether the counsel really said that and to what extent, whether even if he said that, that would offset the other information and indicate there really is justifiable excuse because the defendant was entitled to believe him rather than the other.
Yes,
and
Your Honor.
then finally, whether he would have taken the plea anyway, and all of that's the determination that should have happened as effective assistance?
Yes, Your Honor, and that's the whole point for holding a hearing, right, is to receive the testimony of the witness and understand their credibility based on that live testimony. That's what a hearing anticipates, is for the court to then receive that and see how believable this defendant is in his allegation, how believable the attorney is in his or her memory of that, and what that might have meant for that defendant. Education level, whether or not they had another person talking in their ear, whether or not they were being told something from some other source, all of those things would go into that analysis to put on the correct balance how that factor is supposed to be playing with others.
Do you think that would be the same? Would it be the same required hearing and balancing if, for instance, rather than him alleging that his counsel told him something different from the advisement, that somebody else had told him something different from the advisement? Another lawyer he knows, maybe a non-lawyer?
Well, Your Honor, I'd be wary against any kind of bright line rule on that account. I think it might depend on who that person is. If it's a juvenile whose parent is saying that, there very might well be some kind of very legitimate, justifiable excusable neglect element there. If it's a person who's listening to a friend on the street, probably not. But the court would need to do that weighing. Who is this friend? Who is this parent? Who is this person who might be some kind of role? Maybe it's a legislator. Maybe it's a senator who says, oh, I've got a bill coming down that might change this. That's why it's fact-specific, Your Honor. Yes.
And when you say do that weighing, do you mean at a hearing? So if there's any allegation that he was told by somebody else, there'd have to be a hearing, and then the court would decide the balance?
Potentially, yes, Your Honor, because those specific facts need to be weighed on the record. And I think that that's not too much to ask of a lower court to do, to hold a hearing on those specific factors, because we want the court to be able to look at the marginal impact of each factor. And I believe that's what Wiedemer was encouraging, was Wiedemer now has about 8, if you read it specifically line for line, has about 8 different factors there, where they're looking not only at interpreting the justifiable excuse, but also excusable neglect. And they've been condensed and worked around in a number of different ways, but specifically at Penn site 441 and 442, that's what the court is doing, is trying to enumerate all of these different factors that should be considered. And I believe at a hearing is where the court, who's in that position to do the fact-finding, should receive that information, yes.
Mr.
And I
Fritz,
think-
oh, go ahead.
I'm sorry, just to follow up on the Chief's question, I think, and I'm interested in this as well, what triggers the hearing? In other words, does the defendant merely need to allege, I meet at least one of the Wiedemer factors? Is that alone sufficient to trigger a hearing to then explore all of the Wiedemer factors?
I would begin my answer by saying in this case you don't need to reach that because we've got 3 here. But if the court does need to look at some kind of bright line bottom rule, I would also caution against a bright line rule in that regard, and having this bare minimum that needs to be alleged.
And if I might interrupt.
Of course.
The concern here, I think, is that we're thinking beyond, of course, this case and the 3 factors alleged to exist here, and coming up with a framework. I'm gathering from your answer that we have not definitively articulated what is necessary to trigger a hearing.
Yes, Your Honor, I don't believe that this court has articulated the base requirement for a hearing, but I don't think it needs to, because we have those factors that are going to be interplaying with one another. And I would submit to this court that once you upset one variable, then that throws off the balance of all the others and needs to be looked at with searching testimony. Because I also draw this court's attention to the very last factor, which is whether or not the district attorney or the attorney general is going to have is prejudiced in their ability to defend against the challenges. That's really only something they can know. And they're going to come back with, hey, you know, this is how we're prejudiced. And then suddenly you've got 2 factors at play there. And the court needs to look at, well, do the police officers, do the witnesses remember what's going on here? Is it going to really prejudice the prosecutor? Those things are going to come into play. So it's rare that it would only be just one factor. And how they interact with each other is going to be upset the moment one factor is alleged.
I think, following up on that question, it was on a similar line. I think I heard you say that if you allege a number of factors, you get a hearing unless it bumps up against a bright line rule. I think you said something like that. What bright line rules would preclude a hearing? I guess in what cases is there no justifiable excuse as a matter of law?
Your Honor, there is one bright line rule that this court has held, and that's in Mershon, that if you are alleging only that you had no present need to challenge the prior convictions or to raise the post-conviction claim, then that would fail as a matter of law, because that's the need that you had the moment the statute was enacted and given Fagerhorn. So I believe there is one bright line rule. That doesn't mean to say that there couldn't be others. I would those suggest that the bright line rules that could be read into the Court of Appeals opinions should be rejected. And that's because ignorance is very much butts up against the Wiedemer factors, proper Wiedemer factors. And I draw this court's attention to the language that I believe has been cited by Justice Marquez. In the actual language there in Wiedemer says whether he either knew that it was constitutionally infirm or had reason to question its validity. What else is that other than ignorance? He didn't know or have reason to know that his conviction was infirm. So I believe that that very much is ignorance, and it affects those legitimate Wiedemer factors.
So do you think if somebody said, I didn't go to law school, so I shouldn't be held to a standard of having challenged this within the time period, would that work?
Your Honor, I believe that that would be based on the circumstances of what he's being told from a variety of different sources. We are, of course, presumed to know the law, but I think that needs to necessarily be balanced with our profession and the fact that we should have some faith in who we're appointed as attorneys. This second opinion idea is concerning because you get a public defender and that's your public defender. You cannot go and seek a second opinion or you're paying money, and that subverts the Gideon promise. So I would say, yes, we need to have faith in our own profession, that people can rely on what attorneys are telling them. So I think that that would butt up against if it's something very complicated, the rule of perpetuities. You would need help with that. You would need an attorney's help with that. But if it's just, a basic self-defense claim, maybe not. But that's why it's so fact-specific.
So can I, because of what you just said, earlier you had said it wouldn't necessarily matter if it was your lawyer who told you that you didn't have a claim, say, or if it was your parents, or, but here I just heard you say that lawyers are different. Is there something different about advice of an attorney that makes ignorance a more plausible claim than it might otherwise be?
Yes, Your Honor, I do think that we should hold an attorney who has a duty to advise of immigration consequences to a specific weight, but not a bright line rule. I think it has clearer weight, but not a bright line rule. So I do think that if an attorney whose duty it is to advise you of the immigration consequences or to investigate what's important to you in your decision whether or not to plead guilty, which is really what Pozo was getting at, then you can rely on that, and being told incorrect advice about that important piece is going to be a clearer weighing of the justifiable excusable neglect than if it was in fact apparent. But I don't want to encourage any kind of bright line rules because that would subvert the fact-based analysis of Wiedemer. And so I would then turn to maybe the next couple bright line rules that the Attorney General is asking you to read into and adopt from the Court of Appeals, and that is lack of counsel and indigence. Those are all based on Vigil in 1997, the Court of Appeals case in Vigil, which found that after holding a hearing, the Vigil defendant got a hearing on justifiable excuse. It was even remanded in an unpublished opinion for a hearing. The hearing was held. The court said, sorry, your indigence, your lack of counsel, your ignorance wasn't enough. And then the Court of Appeals, in reviewing that, said, well, we find no unavoidable hindrance under Roe, so yes, we agree that there's no justifiable excuse or excusable neglect. We affirm the lower court's decision. But then that decision has been taken by every subsequent Court of Appeals case to say, hey, these are bright line rules, that if this is what's being alleged, sorry, you'd automatically lose summary denial as a matter of law. But think about the ignorance like I talked about before, and now this indigence and lack of counsel. If you're going to different attorneys saying, hey, I've got this issue, help me, I don't have very much money, and the attorney says, I'm not going to take your case because you can't pay me, that's him attempting to avenues of relief, which is what Deemer's suggestion is that's a factor. If you're pursuing attorneys to help you with this, and they're rejecting you because you're poor, that's very much a Wiedemer factor that the court needs to consider. And then dovetailing off of that is this recent discovery. A lot of courts have said a recent discovery, that's not enough to get you past this standard to get you a hearing. But that's exactly what Germany was talking about, was if your recent discovery had an element of culpable neglect. So to cut them off at recent discovery, carte blanche, period, QED over and out, isn't fair, and it subverts Germany, because Germany is saying that's fine as long as there's no culpable neglect. And that was the promise of Germany, and why Germany suggested the exception, and why the legislature in 1984 adopted the exception and has said nothing more about it. Turning to the other two arguments submitted by the Attorney General, specifically whether or not a substantive claim of ineffective assistance of counsel can also be an exception to the time bar, I would draw this court's attention to how they're both very different analyses, right? The ineffective assistance of counsel requires deficient performance and prejudice, whereas Wiedemer is this series of factors that the court needs to balance. So just because one fact can inform both doesn't necessarily mean it can't. And I would suggest to the court, we have this in other cases, other situations. Take, for example, Miranda and custody considerations and voluntariness. They're different analyses, but a fact can inform both. And so it would be wrong to say because an analysis can't, or a fact can inform both, that it can't. So I think that because Wiedemer is written so broadly and encourages this broad balancing, that a fact that went to both can certainly inform both analyses. And to read into it that it can't would in fact be another bright line rule that is exactly what the Attorney General is suggesting we can't have written into the statute. The Attorney General is arguing that some tolling provision for misadvice would be writing something into the statute and usurping the legislature's role. But on the other side of that, by reading into the statute that it can't also be informed by a substantive claim of ineffective assistance of counsel is itself another bright line rule. And so I would caution this court against adopting that and draw attention to the fact that these Court of Appeals opinions in Chavez-Torres as well as Alvarado-Hinojos aren't saying that there's a bright line rule. It's simply saying the facts in this case implicate the factors of Wiedemer. You need to have a hearing to balance them. They're not trying to write in a tolling provision. They're not trying to say one thing is for sure or for sure not a Wiedemer factor. They are simply balancing the facts.
Can I ask a question? I was
Please.
thinking back when you when you started a few minutes ago talking about Germany and the effect of Germany, effectively saying there would be a due process violation, but unless there was a excusable neglect, justifiable excuse type of exception, some kind of exception. Is it your feeling that unless we were to interpret the excusable neglect provision as broadly as you suggest, that there would actually be a due process violation? And so it's not just a question of what the legislature meant?
If we did not interpret Wiedemer as broadly as I suggest, I do worry that slowly we will return to a pre-Germany place where the exceptions to the exception swallows the exception, and suddenly the person has no meaningful opportunity to challenge his or her conviction. I believe it was Justice Boatwright who talked about, or Justice Gabriel, who talked about if everything is present need and the moment you had present need was sufficient to cut off every claim, then the exception to the time bar is swallowed up, and we return to a place pre-Germany where there is a due process violation. So the more we poke holes in that justifiable excuse and we have these bright line limitations, the more and more we return to that place. And Your Honor, the third argument advanced by the Attorney General is that this idea that this is present need. And so I guess that dovetails with your question, which is whether or not this is in fact a present need argument. And the first thing I noted was that to allow every claim to be a present need argument or to fall prey to that limitation would swallow the exception. The second is to note that he is advancing to this court that the moment your conviction enters, you need to be investigating, seeking a second opinion, and possibly, as Justice Hart indicated, filing your 35C to make sure that you get it in time. There's your floodgates, Your Honor. That's the floodgates, is all of this litigation based on panic, not based on research and thoughtful understanding of what you were told. And it would also dilute the power of our profession to suggest that you shouldn't trust your plea attorney, you shouldn't trust your trial counsel, and that is of equal concern. So those arguments that what the Court of Appeals is doing is establishing a bright line rule is of the substantive claims that can't be both, this court should not heed. Because the concern is that if at that moment defendants should be skeptical, defendants should be worried, we lose a lot of faith in the public defender system where they can't get a second public defender or they can't even afford a second opinion. Also something I was thinking about at the table with this discussion, this ongoing discussion of present need versus ignorance of the law, they are very separate things. And if you'll indulge me for a moment, this past weekend I had some work done on my car, and the mechanics left a flashlight, an expensive $200 flashlight, under the hood of my car that was damaging part of my car. I drove to Adams County on the highway, had no idea it was there, but I certainly had a present need to get it out of my car. So I would suggest that in everyday life, right, these are a very plain distinction between present need and ignorance. And the court does not need to overrule Mershon because Mershon makes sense, right? You had a present need the moment you entered your plea of guilty to challenge that conviction if something was wrong with it. But that doesn't mean you didn't know it was wrong. And what's especially telling about Mershon and the whole reason why the time bar came into being is a defendant isn't going to anticipate future criminal charges and convictions to be able to challenge the potential for future habitual criminal charges against them. But in this specific case where the immigration and criminal law intersection is very confusing, certainly this is a case where ignorance and present need do intersect but are distinct things. If the court has no further questions, I would ask that they affirm the lower courts, or the Court of Appeals, finding that a hearing is required in this case and remand for such. Thank you.
Actually, I'm sorry, before you step away,
No, I'm glad, thank you.
it seems,
Wait, you may have delayed too long.
sorry. The key difference, I think, in this case is the existence of notice in the plea agreement itself. And Mr. Noble, in the last argument, suggested that such notice places, or I may be misdescribing it to Mr. Noble, at some point in the last argument, it came up that plea agreements today will contain routinely these types of notices, such that this is not going to be an issue because the defendant will be on notice. What's your response to that? How does the misadvice overcome the plain notice in the middle of the plea agreement?
Of course, Your Honor, and I would first begin by citing the defendant's attorney, their close relationship and that attorney-client privilege that we've put on that specific relationship, because it is a special kind of relationship where you need to be able to be honest with your counsel and have them be able to give you honest advice in return. So I think that putting a greater emphasis on what you're being affirmatively told by someone who has a special role in your litigation, as opposed to the court, which doesn't get to hear a lot of your background discussions, which is preferable, of course, because you don't want the court to know necessarily what might all be going on in the background, is going to give this general advice. But the specific advice of someone who knows your circumstances is very different. And I think that to allege that, wait a minute, I was told to just stand up there and say yes to everything I was asked, that I'll get the benefit of this deal, that all will be well, should be able to come into court and tell the court that, and the court should be able to gauge then how credible that is, up against a defense attorney who can say, no, I remember standing in the hall, I said these things to him, he did tell me that he was an immigrant, he was undocumented, here's why I didn't pursue information about this, or why I thought this was fine. So I do think that because of that special relationship, just the fact that, yes, in the future we will see a lot of Rule 11s have that subjunctive, this could have immigration consequences, is not going to overrule what a defense attorney might have told specific to his client.
But that's the difference, right? I mean, the notice here says it may have immigration consequences, and then I suppose what happens is the defendant says, well, it says it may, does it? And the attorney says, no, it doesn't in this case. I mean, it would be a different case if the plea agreement, the plea paperwork said, this will have immigration consequences, right?
Yes, Your Honor. But that would be odd, I would imagine, given how complex immigration law is and all the different forms of relief that a person can seek, cancellation of removal, adjustment of status. The complexity of the immigration world would probably always counsel against a Rule 11 having such specific and concrete advice. But the attorney, given Pozo and Padilla, does need to find out that advice. So to that extent, I respect that the immigration context and deportation is a unique field, but going all the way back to Pozo in 1987, when something is relevant to a defendant's decision whether or not to plead guilty, and the defense counsel knows that, it is incumbent on them to research that. And we're seeing this somewhat in the world of parole eligibility dates as well. I don't know if it's cited in the briefs down below, but there's a case out of the Court of Appeals, People v. Sudduth, S-U-D-D-U-T-H, I believe, which talks about, because the attorney ventured to give advice on the parole eligibility date, the fact that was not what the defendant later dealt with, could be ineffective assistance of counsel. That's not a justifiable excusable neglect case, but it was enough to open the doors for the person to have a hearing.
So let me make sure, I think, and coming back to the plea paperwork here, draw a distinction. If the plea paperwork says there may be immigration consequences and the attorney does nothing, says nothing contrary to that, in that case, there may be an argument that there's no justifiable excusable neglect because the client should have asked. If the paperwork says there may be and the client does ask, that's a different world. That's your position?
Yes, Your Honor, and that goes back to the dialogue that's going on in the Court of Appeals right now between Morones, Canones, and De Guglielmo, where the De Guglielmo, and I apologize if I'm butchering that name, was not told anything about it, but then put on notice in the plea colloquy, that there might be immigration consequences, and the Court of Appeals found it was incumbent on him to ask further questions. It was the Morones-Quinones example where she was affirmatively told otherwise.
Okay, thank you.
In this case, I'm sorry, in this case, did your client ask specifically about that part of the plea agreement? Or is it the kind of thing where the attorney said, you're not going to get, there are not going to be any immigration consequences, and then separate and apart from that advisement, the plea agreement happened to contain the language that it does?
Yes, so my understanding of the facts below is that Mr. Alvarado-Hinojos let his counsel know that he was, that immigration would be a concern, and then the attorney turned around and said, it's not going to have immigration consequences on you. Then the day came where he pleaded guilty, saw that paperwork, but relied on his attorney's advice.
Okay, but it's not that your client then looked at the paperwork and said, hey, this plea paperwork says this may subject me to immigration consequences. So which is it, what you're telling me or what the paperwork is saying? It's not like that. What you're saying is the attorney advised him, he looked at the paperwork, and he assumed, based on what the attorney had said, that this wasn't going to make a difference and pled guilty, right?
Yes, Your Honor. I believe, if I'm understanding your question correctly, yes, he received the advice, and he may or may not have seen that language specifically in the plea agreement, but to the extent he did, it would not overcome the affirmative misadvice he received. And so with that, if there are no further questions, I would ask that this court affirm the Court of Appeals decision and remand for a hearing on justifiable excuse, excusable neglect. Thank you.
Thank you.
Talk really fast.
Well, hear me. We're not saying don't trust your plea counsel. That's not at issue at all. We're saying 165402 vests in the defendant the responsibility to investigate any and all claims that may have arisen from the plea context or from the conviction. That is the substantive allegation that requires immediate pursuit, and that is what cannot defeat the procedural bar. Thank you. We ask you to reverse.
Thank you. Appreciate the argument of both counsel. Case will stand submitted, and the court will be in recess until 1 o'clock.